It's Civic Literacy time, and welcome back to FCLE Seminar, your exam prep podcast, where we cover what you need to know to pass the FCLE. I'm your host, Mercedes Musto, and today we're beginning our exam cram on the U.S. Constitution, beginning with the First Amendment. The FCLE tests your knowledge of the Constitution and its application. So we're going to link this stuff back to some very familiar landmark Supreme Court cases. Let's get started. The First Amendment. Okay. First, quick reminder. The First Amendment was ratified in 1791 and is part of the Bill of Rights. It reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of people peaceably to assemble and to petition the government for a redress of grievances. Beautiful. Okay, broadly speaking here, think of the First Amendment as the protection of fundamental rights. According to the Constitution Annotated, that's a website, check it out, this means religious liberty and freedom of speech-related rights. More specifically, the First Amendment has 5 core ideas. Number 1, religion. 2, speech. 3, press. 4, assembly. And 5, petition. Now, we talk a lot about the federal government, and then we talk about the state governments. See, the Bill of Rights, meaning the first 10 amendments, apply to the federal government directly. But through the 14th Amendment's Due Process Clause, they've been what's called incorporated to also limit state governments. So, yeah, that's a lot, and we'll talk more about that later. Okay, back to unpacking the First Amendment with examples. Number 1, freedom of religion. Let's start with religion, which has 2 parts, the Establishment Clause and the Free Exercise Clause. The Establishment Clause prevents the government from setting up or favoring one religion over others. This is commonly explained to us as separation of church and state. You know, you've heard that before. A classic landmark case here is Engel versus Vitale, 1962. Check out episode 11 to listen in on that case. The idea behind that was that's the case in New York public schools about prayer in school, where a parent named Stephen Engel challenged that prayer in school on behalf of his child. And he argued that it violated the Establishment Clause of the First Amendment. Here's how it turned out, see. In a majority 6-1 decision, the Supreme Court ruled in favor of Engel. The majority opinion delivered by Justice Hugo Black held that the state-sponsored prayer, even though it was non-denominational and totally voluntary, I mean, the kids could opt out, did violate the Establishment Clause. See, the court emphasized that the First Amendment's purpose was to prevent government involvement in religious matters and that the state could not compose official prayers for use in public schools. Oh, how about that? I'm sure there's more to that, so you can check it out on oyas.gov. Number 2, freedom of speech. Moving to freedom of speech, the most popular part of the First Amendment, it protects expression, including words, symbols, and actions, but not everything. See, this is an example. The government can restrict speech if it poses a real threat, like you can't yell fire in a crowded theater when there's no fire, see. Remember that example from episode 6, Schenck versus the United States, 1919? Okay. Yeah, that's the case, Schenck versus United States, 1919. That's the one where during World War I, Charles Schenck distributed anti-draft leaflets. That doesn't sound so bad, but see, the court upheld his conviction under the Espionage Act, creating the clear and present danger test. What's that? This means that speech can be limited if it creates a danger that Congress has the right to prevent. This is where we get the falsely shouting fire in a theater example. But like I said, that is episode 6, and do look into that one. Another example that's super great, episode 14, Tinker versus Des Moines, 1969. This is a case where the kids wore black armbands to protest the Vietnam War. They wore the armbands to school, and the school suspended them. The court ruled 7-2 that students don't, quote, shed their constitutional rights at the schoolhouse gate, end quote. In this example, see, the armbands were deemed symbolic speech, and symbolic speech is protected. Like in episode 20, Texas versus Johnson, 1989. This one is another example of a symbolic act, where a guy named Gregory Johnson burned an American flag at a protest. What? See, here in this 5-4 Supreme Court decision, the majority ruled in Johnson's favor, but this one was a close call. Their reasoning, the court explained this act of burning the flag as something called expressive conduct, similar to symbolic speech like Tinker versus Des Moines. So yeah, totally go back and check those out. There's 2. Here are the next 3: freedom of press, assembly, and petition. Freedom of press protects journalism from government censorship. A big case is episode 28, New York Times versus United States, 1971. Oh man, this is the case back in 1971 where the New York Times and the Washington Post newspapers began publishing excerpts from a classified Defense Department study known as the Pentagon Papers. This document contained information about the United States' involvement in the Vietnam War. Now, the president at the time was Richard Nixon, and his administration argued against the publication of the classified Defense Department documents, saying that it would harm national security, and then invoked a thing called the doctrine of prior restraint. This is like a type of censorship that occurs before. In this case, basically the government was trying to stop the confidential information before it actually had been printed, claiming that it would harm national security. I mean, that makes sense, but what was the outcome? The outcome was the Supreme Court rejected the government's attempt to block publication. The court ruled in favor of the newspapers, really in support of freedom of press. While acknowledging the government's interest in national security, the court emphasized that prior restraint of the press was a drastic measure and should be used only in the most extreme circumstances with necessary proof. Ooh, that's a quick exam cram First Amendment review if I've ever seen one. And really, there's so much more to know about freedom, liberty, and the U.S. Constitution. But in a nutshell, just remember for the FCLE, the First Amendment is about protecting individual liberties by limiting government power. That's all for this episode of FCLE Seminar. If you've got thoughts on the First Amendment or you've got something really intriguing to share, hey, then hit us up in the comments. You can find us on Spotify, Apple, or YouTube. Until then, keep questioning, keep learning, pass that exam, and stay curious. This is your host, Mercedes Musto, signing off.